We have another subject you're all going to be really excited about. But we have the person on the agenda with the best, most appropriate name. Berry treats our next speaker on basically on intellectual property, which we're all getting more familiar with as we get into these things. And I think he had an agenda asking Chad how much appropriate costs.
Somebody's going to pay for it.
I'll let you introduce yourself.
Okay.
There is a mic here, Barry.
How about that? Here we go. Okay. Well, I'm back. I was here in December talking to the group, so you didn't beat me up too bad, so I'm back again. And I guess I'm going to talk today about licensing. And, you know, I do licensing for all the technologies coming out of OSU. And we're pleased to have the USDA contributing varieties to OSU to help, so we can help the program and direct some of the majority of the royalties that we get from licensing back to Bernadine and Chad to fund their program. So at a very high level, that money goes back. So this is my agenda then to look at the USDA varieties again, and I'm going to go through that quickly. Commercial propagation license to sell and use, we'll talk about that. And then patent and infringements. Okay. Here is the things we're working on for Chad and Bernadine. So we have the master license from USDA at OSU. And, so we're responsible for licensing their material and then providing those royalties that we get from the propagators back to their program. And here's the varieties you already know, but there's a patent number associated with these. And so the USDA will patent and protect their varieties for the United States, like most breeders do today. Here's the most common types of plant intellectual property. This is property of the breeders, and they can hold that in trade secrets, as in corn hybrids, soybean hybrids. Most of the Midwestern plant breeding companies use hybrids. Tomatoes are hybrids. And so they're secrets kept, and you really don't need to do anything, just keep your secrets of how you made that cross. So that's most widely used in the United States by private breeders. And then the patents are mostly for around GMOs, using genetic markers are patented. Those are utility patents that can be protected around the world, just like any other patent, but they're plants, most likely plant-oriented. Plant patents, which are just one claim. There's no additional claims, just the plant itself, where patents has multiple claims, utility patents. And GMOs would have multiple claims, 30 or 40 claims to a patent, but in plant patents, it's just the plant itself. And those are clonal, which raspberries are clones, so that's where we would protect raspberries, is in the plant patent. Plant variety protection then is your seeded crops, wheat and barley, oats, tomatoes are plant variety protected. That's a fairly unique way of protecting for the United States. Some other countries now are following that procedure quite widely now. It's being adopted in a lot of places. Plant breeder rights are the international protection under treaties where 65 countries recognize all of these sources of protection. So we can file our plant breeder rights in Canada, in the EU countries, and all the developed countries, and protect ourselves in those areas. And trademarks is another very important way of protecting a brand. So if you have a brand with a Sunworld, citrus, things like that, where they use trademarks to protect their materials. Here, inventors will, in a patent, inventors will publicly disclose how it was made and provide the patent office all their secrets. That's published, so every breeder in the world can see how he did it, basically. How did he invent that new variety? And in exchange for that information, the breeder, the owner, gets 20 years protection, and only he can sell that material for 20 years. And then it's turned back to the public. Anyone can now use it after 20 years. But this is how Edison used his inventions of the light bulb. He had 20 years to exploit that and become very wealthy from the light bulb. It's the same principle in plants that we're using in the plant patent method as well. So it prevents others from selling or using the plant. And in these terms, I'm talking about propagation and selling. So if you're propagating that plant with the intention of selling, you need a license to do that. And if you don't get a license, here we're talking about infringement then. If you go ahead and take somebody else's material and start propagating and selling it, there's quite a penalty for that. And evidence of infringement can be done, through today is mostly through genetic markers, fingerprinting varieties. We can readily tell what variety is which one, and if you own it, you have markers that can identify your variety, and you can stop the ship that's coming from Argentina or Chile that stole your variety. You can turn that ship around and send it home. And the customs officials have worked with me to do that in citrus and blueberries. So patent owners may request a court injunction. So it's a court order to prevent any more selling of that patented plant. The patent owner might file a complaint with the U.S. Federal District Court, which is, now you're into some big money, $1 million suit. There are very few of those in federal court that are less than $1 million. So if you can afford $1 million to fight a case in federal court, most of you can't, and I couldn't. So there's some heavy penalties that are possible. So don't want to get in that situation. So a propagation license, we'll issue this, and it's very a reasonable license. Here's the grant of the license. This is the heart of any license agreement. So you can read that yourself. But it basically says that you have now permission to make, use, and sell, and propagate, and offer for sale this variety. And here's our license for most berry crops. $300 upfront fee. This basically pays for our paperwork and handling and record keeping. Get that started. There's an annual royalty of 30 cents per plant, and then minimum royalties of, after 2 years, actually, these minimums kick in. You have to sell at least $300 worth to keep that license. And the terms are generally 5 years. They can be renewed without an upfront fee, so it's just continuation of that royalty. So that 30 cents takes a lot of plants to pay for Chad's program. That's why I was asking, what does it cost? And $500,000 program a year, you'll never get that money back in royalties. So it's a way, though, to track that there is a need, there's a grower demand for new varieties, and it helps us justify this program at OSU, helps the federal government justify spending tax money, your tax money, to support that, subsidize this crop. So very important to sign these licenses, get them in place here, and continue to sell these varieties. So that's about it. I'll stop there. Any questions anybody has? I think there'll be a panel next, so we can go into that as well.
Yeah, I think the main, or one of the main issues with our industry is there has been a lot of self-propagation of non-patented varieties on the farm.
Right.
And so this is going to be a real change in culture to some folks. But
Right.
Columbia Stars, say, and have restrictions on farm propagation.
Right, yes.
So that guy, could you go through that scenario, what that grower would need to pay if you did want to self-propagate?
Yeah, that's the same license as everybody else would have. It would be a $300 fee for that license. You want to do your own farm, or self-propagate on your own farm, it would cost you a license and 30 cents a plant that you produce. So it's no different from a self-propagator.
Barry?
Yes.
Could you go back to the previous slide for just a sec with those fees? So the question I had is, it relates to the term of 5 years and the 300 per year minimum. So let's say we have a scenario, follow up to Tom's question, that you're a grower and you buy an acre worth of plants from a licensed nursery.
Yes.
And you decide you love this variety and you want to self-propagate. And so you buy to be legal, you buy the propagation license for
Right.
$300, and that license lasts for 5 years, correct?
That's correct.
But there's a $300 per year minimum. So my question is, if you propagate all the plants you need for that additional 5 acres, and you pay your 30 cents a plant cost plus the $300 license fee, do you need to continue to pay the additional $1,200 for the remaining
No.
4 years?
No, thank you for
Okay.
that question. No, you don't. You can terminate that license when you're finished with it.
Thank you.
You have to pay 30, if you
Yes,
start
sir.
out with a 1 acre and you go to 5 acres, you're gonna pay 30 cents every year, as long as that field's in existence, up to 20 years.
No,
That's
on the
deceiving on
plants.
this.
It's only
That's-
one time for that one plant.
For the
It says
propagation.
annual, 30 cents.
If you were a
Per
nursery,
plant.
you would pay annually for everything you sell.
But if you just propagate it and plant it and harvest the fruit off of it, sell it to a processor,
You're fine. You don't need
You're all
to
right.
pay a royalty on that.
You only pay for a plant once.
Right. We don't want to double dip on royalties. Only one time and exhaust that royalty.
In a 1 year period, if your royalties of 30 cents a plant exceed the $300, you still have to pay the $300 plus, okay.
Oh, you don't pay plus, no. If
Okay.
it exceeds it, it's just the royalty. that
Once you
you pay.
hit $300, you're good to go.
Yes, yes. Yeah. Maybe I'm wrong on that. When I heard your last comment, it's the amount of royalties. If it exceeds $300, you still owe all the royalties per plant.
Right, yeah, yeah. But you don't have to pay the extra 300 because you've already paid it.
No, that's just a default load.
To sell 1,000 plants,
3,000.
Well,
So
hold on,
this is-
can I double check that? So it says $300 upfront propagation license, so you have to pay that regardless.
Yes, to get the license is $300
Yes,
fee.
and so then you need to pay 30 cents a plant.
30 cents a plant that
Got
you
it.
propagate.
It's only after that, the 300 per year after that, you do not need to pay as long as you sell more than $300.
Yes,
Okay,
as long as you sell more than 300.
That's only if you're selling, not if you're just planting them back in your own.
No, that's if you're planting them back.
If you're planting them back in your own field, you still got data, okay.
If you're using those, if you're using it, you owe.
So the 2 annual royalties aren't both together, it's an either or.
Yeah,
Right.
whichever is
Okay.
greater.
Whichever's greater, yeah.
yeah.
Sorry, that is confusing.
It might be helpful, like for me, and maybe some other folks too, is to somehow show this in some kind of like flow diagram and show a couple different examples. It sounds like there's a few different scenarios that could play out.
Okay, yeah.
Maybe you should put this information into a packet, and when a plant breeder sells plants, that packet should go with those plants, so that the person buying the plants knows the conditions and terms of the policy.
Contract.
Yeah, with an MTA, going with an MTA or something like that.
Yeah.
That's a good idea. Material transfer agreement where the breeder is
Yeah,
testing varieties. Yeah, that'd be a good idea. Thank you.
I think the thing, at least in my mind, we want to avoid is people becoming aware of this over violation. we want to get people educated up front as much as possible, because this is a real change in culture for a lot of our growers.
Right. Right. Well, I might repeat myself again, on the MTA, the material transfer agreements, if you're testing for a breeder, there's limits of what you can do with what you're testing. There's an agreement that goes with that material already. It says you can't propagate it. You cannot do anything with it other than test and evaluate. You can't multiply it. Unless it's released. All of these are released through the USDA and provided to us to license. And everything you get in a material transfer agreement wouldn't qualify for that. They have to be officially released.